So here's one that may also have some ethical implications. Not all counsel share 100% of information in discovery or investigation with their clients. That's a discretionary thing, although the client owns the file and ultimately could compel access. There's been cases I've been familiar with, whether it's plaintiff or defendant, doesn't want to know where doesn't want the opposition to know where they live or where they work. Not that there's a protective order or anything of that fashion, and through discretion, the counsel representing that party that wants that information may withhold it, but given the different security levels, it also includes parties. So what might a practitioner do from a technical and an ethical standpoint if they encounter that dilemma that the client wants this PII that would normally be redacted, not available to the public, but available to a party?
I'm going to let Kathy take that first.
Well, if certain information, I think you would still use the same redaction process. And then I think if someone else wants it, it becomes an issue for a trial judge. But address currently, courts can put and mark someone's address as confidential. Correct. But that means that that information came in on a confidential filing information sheet. So if you're really trying to protect someone, and this may come up most likely that we see with the courts in orders of protection, that they don't want the respondent to know the petitioner's address, that address isn't even shared with the other party. So I think it kind of depends on the case type that you're talking about and who you're trying to protect the information from. If you're trying to protect the information from the public, you would just want to make sure that the public-facing document is redacted and that the full document filed with the court has the information that the parties and the court may need. However, if it's something that you're trying to not share with the other side, I think that would be your normal either discovery or other sort of litigation practices that you have on protecting that information.
Right. It might be that if there are particular reasons why, David, you could file a motion for protective order and say, I don't want to share these two things, and have a hearing, and then the trial judge will sort it out for you.
Well, and specifically, and Melinda, what if it's your own client that wants access and you feel it's not in their best interest, but they say, hey, according to COR 2, I'm entitled to it at this security level?
But what the client is entitled to ethically is under Rule 4-1.22 on your client file retention, and then you read that with the Couples case and with Formal Opinion 115. And so, yes, while Missouri does have this cover-to-cover provision when it comes to the client owning the file, certainly there are some limitations to that, and we have a number of informal advisory opinions in our office, and we have a resource page on our website too about file retention and frequently asked questions. And so when you get into the context here of, well, is that other side or is your client actually entitled to this information, or is this information somehow otherwise protected by other law? There are certainly some questions there too that you may not be able to turn that information over to your client if they're not legally entitled to have that information because it's protected by some other law.